For decades around the world, inventors were able to file U.S. patent applications directly with the U.S. Patent Office. An inventor in India, China, Brazil could create their own USPTO patent account, upload their patent applications, pay their filing fees, and at least theoretically represent themselves. That pathway, however, is rapidly disappearing. In this video, I want to talk about the legal, technical, and practical barriers that foreign inventors now face when trying to file a U.S. patent application without a U.S. patent attorney. More importantly, I'll explain why some of the biggest risks won't even appear until years later when the patent is being enforced or challenged. Hi, my name is Carr Ferrell. Welcome back to my channel. So what is it that's changed? Well, beginning July 20th, 2026, the Patent Office will require that all foreign domiciled patent applicants be represented by a U.S. registered patent attorney or patent agent. Now, there's two important things to understand about this new rule. First of all, the rule is based on domicile. It's where you live with the intention to stay for the foreseeable future. If you're domiciled in Italy, if you live in Italy, and you're filing a patent application in the U.S. Patent Office, then you're required to use a patent attorney or patent agent. However, if you're from China and you live in the United States, say you live in San Francisco, although you're a Chinese citizen, so long as you're living in San Francisco and domiciled in San Francisco, you can file your U.S. patent application yourself. A U.S. patent attorney or patent agent is not required. The second important thing to understand about the new rule is that inventors, companies, and universities can still get patents in the United States. The only requirement that's changed is that foreign domiciliaries must be represented by a U.S. representative, a registered patent attorney or patent agent. Now, one of the things that's easy to confuse is the difference between domicile, mailing address, and citizenship. Legal domicile is not the same as someone's mailing address. For purposes of this Patent and Trademark Office rule, a mailing address is where you get your mail. It might be your brother-in-law's house. It might be a UPS mailbox, but it's a location where your mail is sent. Domicile is different. Domicile is where you live with the expectation of staying there. Consider, for example, an inventor who lives in Rome. He sleeps in Rome. He works in Rome. His family lives with him in Rome. He pays taxes in Italy and he maintains a residence in Italy. He is domiciled, very likely, in Italy. Now, say, for example, our Italian inventor has a cousin in San Francisco. Our Italian inventor uses the San Francisco address for receiving mail from the Patent Office. That's the correspondence address from the Patent Office, may be in San Francisco. However, our inventor is still domiciled in Rome. So for purposes of hiring a patent agent to represent him on his patent applications, since his domicile is still in Italy, still in Rome, he's required to hire a patent attorney to do business with the Patent Office. So for purposes of this rule, there's a distinction between mailing address and domicile, and the only thing that matters is domicile. Now, likewise, for purposes of this rule, citizenship does not matter. It doesn't matter that he's a U.S. citizen. He's domiciled in Rome, and therefore he's required to engage and be represented by a U.S. patent attorney. Okay, one of the questions that comes up somewhat disturbingly is, isn't there a way to work around this requirement for hiring a patent attorney to file a patent application in the U.S. Patent Office if you're a foreign domiciliary? Is there some kind of hack that we can use? So let's think about some of the obvious workarounds and why they probably won't work. The first workaround is, can't we just use a U.S. address, like maybe a mailing address of our cousin or mail forwarding service, for example, or an apartment address of a friend. If we fill this in on the ADS, the application data sheet, it seems that the Patent Office is just going to use that address in order to determine our residency. So isn't this a workaround? While it is true that the Patent Office may or may not catch this, the rule requires that if you're a foreign domiciliary, that is, you live, as we've discussed, overseas, not in the U.S., you're required to use a U.S. representative in the Patent Office. If you use a U.S. mailing address, it's likely not to match up with the ID.me information that you entered to get your registration verification, and thus likely it's going to require and cause inquiries from the Patent Office. Additional evidence will probably be submitted, and likely they will find out at some point. And there are problems if they don't find out, which we'll talk about in a bit. So emphasizing again that merely entering a different address is not going to change your domicile. Now, the second workaround that might come to mind is to use a VPN, a virtual private network, when filling out the application form online. Now, a VPN is a remote router that takes your current location and runs it through a router at a different location, making it look like you're actually present at that different location. For example, you can be in Shanghai and contact the Patent Office through a VPN server located in Los Angeles, and it will look like you're actually contacting the PTO from Los Angeles. And although this may change the apparent location of the contact with the Patent Office, in fact, it does nothing to change your domicile. As a simple example, you might be standing in Rome wearing a San Francisco baseball cap. And people who look at you may see the cap and think you're from San Francisco. But in reality, you're still standing in Rome, despite the signal that you might be sending that you're from someplace else. Besides, it's pretty likely that the government has networking equipment that's sophisticated enough to identify that your incoming messages, that your incoming data traffic is from a VPN server. And they'll thus probably either block you or require that you provide some additional authenticating information. So what happens if you just ignore the rules and nobody notices? You file a provisional patent application, it gets accepted, the year passes, you then file a utility patent application, and then eventually your patent issues. So what's the problem? So this is kind of the worst of all worlds, because now your patent is issued, it may become extremely valuable, and then years later you go and you try and enforce the patent, and you're required to litigate the patent, or you sell the patent to someone who tries to enforce it. And then this deception surfaces, and now you're being accused of fraud on the Patent Office. Certainly your patent's going to be held invalid, unenforceable, and you'll have additional legal problems likely based on the fraud and the perjury that was committed earlier. And it might be just worse than a single patent. You might actually have foreign equivalents that spin off of this original patent filing, as well as a family of patents and patent claims that may grow. All of these patents then would be held invalid, unenforceable, based on the earlier failure to follow the rules. And really, what's all this for? Is to save a few dollars in hiring a patent attorney or a patent agent to help you get your original patent application on file. Now, with respect to provisional patent applications filed from inventors in foreign countries, there still is an open question as to whether the provisional patent application will be granted a priority date, even if a U.S. patent attorney is not used in the filing of that application. Now, at the time of this video, and this is before the July 20th implementation of the rule, it appears that the Patent Office will accept the application and give a priority date on the date that the application was actually filed. Now, even though the priority date, the filing date of your provisional patent application, may be assigned and valid, the application itself may not be valid because of a failure to involve a U.S. patent attorney. Now, there is a bit of ambiguity about this. However, the current understanding is that there are two documents that must be signed by an attorney, by a U.S. patent attorney or patent agent when filing a provisional patent application. If you're a foreign domiciliary, that is, you're filing from outside of the United States, the ADS form, that is the application data sheet, must be signed by a U.S. patent practitioner. The second document that needs to be signed by a U.S. patent practitioner, that is a patent attorney or patent agent, is the verification of microentity status. So if you're filing your provisional patent application as a microentity entitling you to reduced filing fees, then that verification form must be signed by a U.S. patent practitioner. Now, the complexity here is that you may or may not get a notice from the Patent Office that your patent application is defective for failure to have a patent practitioner sign the ADS form. And the problem that results from this is a year later when you file your utility application, you may go back and claim priority to that original provisional application, which was defective. And so that priority date from the original provisional patent application may not be useful for claiming priority for the non-provisional utility application. And if your provisional patent application was defective, then the current non-provisional utility patent application that you're filing and working on now is also defective, and you're going through a lot of time, effort, and expense for a patent that may even issue but will not be later enforceable. And as I mentioned, there's still a bit of ambiguity here, mostly arriving from some of the comments that were generated during the rulemaking process. However, the rational approach is that after July 20th, when you're filing a provisional patent application and you're a domicile of a foreign country, use a U.S. registered practitioner. So it's pretty easy to get a little exercised over this whole process, this requirement now that you have to spend money on a U.S. patent practitioner if you're filing a patent application from a foreign country. That's totally understandable. The Patent Office, however, has identified a couple of reasons why they feel that this new requirement is necessary. First of all, filing patent applications is difficult. It's procedurally difficult, and preparation of the application itself is difficult. The Patent Office says they were spending a lot of time and resources dealing with defective applications, defective claims for priority, and most importantly probably is the calculation of fees, improper claims of microentity and small entity status by applicants who weren't entitled to the discounts. The second concern expressed by the Patent Office was that surrounding fraudulent submissions and unauthorized access of patent records. And by tightening up the rules and dealing with patent practitioners who are licensed by the Patent Office feels that they could have better control over access and quality. The third concern raised by the Patent Office was there had been a cottage industry that was growing in Europe and other places where unauthorized practitioners, just average people, would claim to have expertise in filing patent applications in the U.S. Patent Office. These patent consultants and invention promoters were seen to be taking advantage of inventors located in foreign countries, particularly the complexity of dealing with the U.S. Patent Office. And the U.S. Patent Office wanted to get control to the extent possible of this predatory third-party behavior. And finally, the U.S. Patent Office in the past has been one of the very few commercially important patent offices, countries in the world, where a non-practitioner could access the Patent Office and file patents from foreign jurisdictions. So this was partly due to harmonization, where now the U.S. Patent Office is in line with Europe, with Canada, and with other countries that require the hiring of patent practitioners by those outside of the country who want to take advantage of the country's patent system. So in wrapping up, just a couple of bits of practical advice. Be honest with the patent system and Don't try to use a residency mailbox or a third-party mailbox from outside the United States in order to spoof the system or to get around the requirements. The patent process will go so much more smoothly, and your resulting patent will be so much better in the end. And as always, if you need help with your patent application or your company's patent portfolio, we'd be delighted to help. You can reach me at the email address below. Thank you so much for watching this video. I'll see you on the next one.